Good morning. My name is Melissa Davey, and I am a Chapter 13 trustee here in the Northern District of Georgia, assigned to cases in the Atlanta Division and the Noonan Division. And I am a member of the Bench and Bar Committee. And on behalf of the Bench and Bar Committee for the Bankruptcy Court for the Northern District of Georgia, I would like to thank you all for joining us for our Lunch and Learn program today. Today, we're going to do a Back to Basics program. And we're going to talk about everything you need to know about motion practice. This is an actual Zoom meeting and not a webinar format. So I would ask everyone to please just make sure that you have your phone on mute or your video on mute. And if you have any questions, we're going to hold those until the end. And we're going to use the chat function. So hopefully you can all see the chat function. And please just type your question and we'll try to get to as many as we can at the end. I have the privilege of introducing our panel today. First of all, we have Aaron Anglin from Jones & Walden. Aaron is an attorney with Jones & Walden and represents small businesses, individuals, and creditors in chapters 7, 11, and 13 bankruptcy cases and other litigation matters. Before joining Jones & Walden, Aaron clerked for the Honorable Jeffrey W. Cavender and the Honorable C. Ray Mullins in our bankruptcy court. And before that, he represented mortgage creditors in chapter 7 and 13 cases. We also have Brandy Kirkland. Brandy is a staff attorney for Ed Saphir, one of the other chapter 13 trustees in the Northern District of Georgia. And Brandy has been a staff attorney in Judge Bonifel's courtroom for almost 18 years. We also have Janine Treese. Janine is the Assistant United States Trustee for the Northern District of Georgia and the U.S. Virgin Islands, and she was appointed to that role in May of 2019. Prior to that, she has been a trial attorney with the program since 1998. And before joining the United States Trustee Program, she was in private practice for 6 years, representing creditors, creditors committees, and consumer and business debtors in Chapter 7, 11, and 13 bankruptcy cases. And finally, we have Shannon Worthy. Shannon is the owner and managing attorney of Stanton and Worthy LLC, which is a consumer bankruptcy law firm. All right, so thank you very much. Our panel today, we're going to talk about everything you need to know about motion practice in bankruptcy court. Specifically, we're going to talk about filing motions and the requirements, service of motions, hearings for motions, and then proposed orders. And our first topic today is motions, and Aaron is going to talk about that. So Aaron, I'll turn that over to you.
All right, thank you, Melissa. Let's see, make sure I got PowerPoint going here. So kind of starting from the top, and I think our first point here is the most important for before you get started. And it really applies to motions, orders, how you generally handle yourself before the court. If your judge has indicated their preferred procedure for the motion you're filing or the type of relief that you're seeking, then follow their procedure. Every judge in the district has information on their webpage. Some have various forms, others just have general procedures for scheduling hearings or setting motions on an expedited basis, all of these kinds of things. So it's to your benefit, it saves a lot of time for you, your client, and judges' chambers if you check their website and follow their procedures and just try to get the information to them the way that they want the information presented. If you're seeking relief on an expedited basis, as that tends to happen in bankruptcy cases as they go on, then follow your judge's procedures for that. For example, Judge Hagenaw has on her webpage, she has an available hearing dates PDF, and included in that is that attorneys are requested to contact Nicole Williams to obtain a date and time for an expedited hearing. Other judges may have a particular contact person. They may request communication by email and including all counterparties to that email. So just check and with your judge, check their website, check their procedures, so that you can make sure that you're following along with the procedures that they're expecting. Saves a lot of time, saves a lot of energy, and you can get it right the first time. Some basic format requirements for the motion. I'm not sure about everybody else, but I spent a very long time doing all of these without knowing that there was a local rule that prescribed them. But there is. Local Rule 5005-1. Several of the things that are required for the motion are the caption. It has to contain the chapter number, the debtor's name, the case number, and the initials of the judge to whom the case is assigned. Anyone who's been around a little bit is familiar with all of that information being at the top of every single pleading before the court, and it is required. After that, the titles on the papers. All of the pleadings and other papers presented to the court have to bear the designations of their content. The title should tell the reader, whoever that may be, everything that you're seeking in that motion. If you combine multiple types of relief into one motion, then you want all of that to be in the title. Except for a certificate of service, which is required for every motion, but you don't put that in the title. And then lastly, at the bottom of the motion, your signature block. So every signature block needs the attorney's name, address, telephone number, email address, and the attorney's bar number, or if not, if the attorney isn't a member of the bar, the state and bar number of the bar that the attorney is a member and regularly practices. This information, as we were preparing for this, and in my experience in practicing and as clerking, these signature blocks are really where you're giving your contact information. Whenever you file a motion, if anyone needs to get in touch with you, they're going to look at your contact information on the motion. And that includes chambers, that includes other attorneys in the case. So having accurate information there is going to make everything easier to practice law generally. Communication is key, and communication outside of the courtroom is key. So once we have all of those requirements, well-drafted pleading should include a comes now statement or something similar, just an introduction. I've seen a lot of motions that don't use comes now, but identifies who the party is seeking relief, and gives a nice introduction, just as if there was a comes now statement. Also need, every motion needs a body outlining the facts and legal issues that you're seeking relief for, and a wherefore clause clearly stating the relief requested. In addition to this, make sure you attach all relevant exhibits. You can supplement that if you forget to on the initial motion, but you want all relevant exhibits to be presented to the court before your hearing or before the court makes a determination. Next, when drafting the motion, you need to establish standing for the relief requested. That oftentimes is part of the introduction or part of the first few numbered paragraphs after the introduction. You need to say who you are, who you represent, and why you're entitled to seek the relief that you're seeking. If you're requesting monetary relief, you want to state the exact amount, let the court know exactly what you're requesting, and trustees and all other parties involved, and how that amount was calculated if it's not obvious. If there's interest that's running and you want to recover interest, then you need to state that. And any equitable relief that you request, just make sure it's available as a result of the type of pleading you filed. For example, a discharge is not going to be denied by motion that requires an adversary proceeding. I think we probably see this more often with pro se pleadings, but it's important as an attorney that you keep in mind the manner in which you should request the relief. Sometimes by motion, sometimes you may need an adversary proceeding. Make sure that you include all necessary information and make all arguments in the motion. Cite your cases, to support your position and the statutes. If you're seeking, whenever you're seeking relief before the court, it's probably based in the bankruptcy code. So state which section of the bankruptcy code allows for this type of relief. If you need to reinforce that, or it's just generally good practice to include case authority where the decision that you're seeking has already been made based on similar facts, that always makes it easier to get the relief that you're seeking if it's already been done. And it saves some time for chambers in determining whether this is the type of relief that can be granted under that code section. Don't expect that the court will make your arguments for you. Sometimes you may get lucky and the court is well aware of the motion you filed. They've already looked at it. They've determined the relief necessary. But the strength of your motion and the arguments made in it will make that more likely. And we'll let everyone know what the issues are before arriving at the hearing.
Hey, Aaron, can I jump in for a moment?
Absolutely.
I just wanted to reinforce that by saying, I know that a lot of us are in a volume practice, and so we have forms that we use for certain motions that we file. But remember, your clients, your debtors, they're individuals, and they each have a story. So if you're asking the court for relief, make sure that you include the relevant facts, particularly if there's some sort of hardship. And also let us know when you're corresponding with the Chapter 13 trustee or other parties. For example, if your client needs to buy a house and they're buying a 5-bedroom house or a 6-bedroom house and they appear to be just a married couple, we may have questions about why that is. But if they all of a sudden just got custody of their 5 grandchildren, that would be good to know. So just think about that. You don't have to divulge confidential information, but even if you can signal that there's a serious medical issue or something like that, it is really important for us and for the court, obviously, to know so they can make the correct ruling based on the facts. Thank you.
Thanks, Melissa. And to that point, as Melissa said, individuals all have their own stories. They all have various things happening in their lives that may be relevant to the relief you're seeking. Small businesses may also have similar stories and similar issues. There can often be a challenge to determine how much you want to disclose in the motion of your client's personal information versus, since it does become public and it can be accessed online. But one strategy that I've done in the past is to let the Chapter 13 trustee staff attorney know what's going on, maybe a little bit more information than what's in the motion. It may be more than you wanted to put into the motion, but you don't mind sharing that information with the trustee, who can keep it not in complete confidence, but kind of contain where that information is going. And then if necessary, you can bring that up to the court. And also to Melissa's point about form pleadings, it can be a help in some instances, and it can be a problem in others. You just want to make sure that whenever you're using a form, it's the right form, it's seeking similar relief, it's based on similar facts. And if not, you may need to supplement the form or change it to meet whatever your particular situation is. And when filing motions, for instance, a motion to sell real estate, you want to attach all of the relevant exhibits, such as the purchase and sale agreement. But you don't want to just leave it as, here's the purchase and sale agreement attached as Exhibit A. You want to say the relevant information from the purchase and sale agreement. When is the closing date? What's the purchase price? How much was the earnest money? You also want to include relevant liens on the property in the motion. If you're trying to pay those liens at closing, you want to include all of those requests in the motion. And it can really speed things up at a hearing. It can, it may prevent the need for the court to hear the motion if all the information is there and it seems that the the relief requested is appropriate. There's a special category of motions that we see in Chapter 13s, less so in Chapter 7s, but it's motion to extend or impose the stay. So that's under 362 C3 and C4. And there are timing requirements on these motions. If you read through the code, these are pretty long code sections, but they're also information dense. So read them carefully if you haven't before. One thing to note is that the notice and hearing must be completed before the expiration of the 30-day period under 362 C3B. That's whenever one case has been pending and dismissed in the last year. Under 362 C4, the bankruptcy code allows 30 days from the filing of the case for a hearing to impose the stay. What happens if you miss that 30-day window? Check your judge's procedures again. And some judges require a showing sufficient to meet the preliminary injunction standard to impose the stay if the hearing is untimely, which is, it's good that you haven't missed your opportunity to impose the stay, but it's a different standard and a different presentation will be required, including either evidence or by the testimony of your client or proffer to the court of what your client would testify as to. In motions to reopen bankruptcy cases, that there can be any number of reasons to reopen a case, file a 1328 certificate, add creditors, disclose assets, and sometimes that reopening the case would also require a trustee. For adding creditors or 1328 certificate, no trustee likely needs to be appointed. But if adding assets, then a trustee likely will need to be appointed. And the slide says reappointed here, but as we were preparing and speaking with Janine, it really should just say appointed. That it doesn't have to be the same trustee that was there, that was in the case before. But if a trustee needs to be appointed, then the United States trustee will take care of that. But the order needs to direct the United States trustee to appoint a trustee in the case. But it shouldn't order the reappointment of a trustee or the appointment of a trustee. It should leave it to the United States trustee to appoint that person, but it should direct them to do so. Janine, did you want to add anything here?
Nope, you covered it. Thank you.
And that's the end of my portion. So moving into service.
Yes,
Erin, this is Melissa. Could I I'm
Yeah.
sorry, just one before we go to that, I did want to mention, oftentimes as a 13 trustee, we get emails years after a case is closed about claims that come up. And we've already been discharged as a 13 trustee. Technically speaking, the United States trustee is the one who needs to make a call about whether the case needs to be reopened. So whenever you as counsel receive emails from outside counsel about those matters, it's helpful if you send an email to the United States trustee and include the previous trustee, whether it's a 7 or a 13 trustee, so that the right parties are notified. And with that, I am going to turn it over to Brandy, who's going to talk about service. Thank you, Brandy.
Yes, thank you very much. And thank you all for joining us this afternoon. We all very much appreciate it. Yes, service. So even if you draft a perfect motion, if your service is lacking, it's your motion, and the subsequent order that you get on it, if you get one, is essentially worthless. So you have to make sure that service is proper. And as the old saying goes, a good lawyer knows the law and a great lawyer knows the judge. So if you're filing a motion, the first thing that I would do is go to that particular judge's website, just to make sure that your form notice of hearing is correct and that all of that judge's preferred procedures are followed. It will save you a lot of time and money in the end if you do that first. And while I'm speaking of judges, some of you may be too young to remember Judge Massey. He retired several years ago, but he was a force on the bench, especially when it comes to service. And he wrote a manual, I'll call it, on how to perfect service on all types of motions, adversary proceedings, contested matters, etc. And you can find his manual online. The web address is in the materials. And although Judge Massey originally wrote the first drafts of the manual, it has been updated by several law clerks, which we are very grateful that they are keeping this manual up to date and available for all of us. So I would highly encourage you, after you go to the assigned judge's webpage first, then you visit Judge Massey's manual to make sure that all of those procedures are followed as well. It's a lot of work up front, but once it'll be worth it in the end, I promise. It'll save you a significant amount of time and money. Also, another good resource, and the website is in the materials, is the Secretary of State's website. It's very important in service that you get the name of the individual or the entity in which you are serving correct. So if you are filing a motion and it involves beneficial, and that's all you list is beneficial, and you get an order or a judgment against beneficial, how effective is that order or judgment? It's probably not going to be very. So it's important to make sure that, you know, if the entity that you're that you need to serve is Beneficial Financial Incorporated, that's what you list. It's because, you know, otherwise, have you technically served them? Probably not. So a good way to find out the actual name of the entity or the individual is via the Secretary of State's website. And also, you know, just Google is a good resource as well, or any search engine. All right, so a lot of people get hung up when they are trying to serve an service or an agency of the United States of America, particularly the Internal Revenue Service. The Internal Revenue Service has special requirements. They have a preferred service address. It's the one in Philadelphia. I'm sure you have all come across it before. But when you are serving an officer of the United States of America or a service like the IRS, you know that you're going to have to serve at least 2 people always and forever. And that's going to be the civil clerk at the Office of the United States Attorney for the district in which you're filing your motion. And then separately, you are required to serve the Attorney General of the United States. In these capacities, it's probably best to address them as civil clerk, Office of the United States Attorney, Northern District of Georgia, because if you name an individual, there's a chance that that individual could resign, retire, whatever, and it would be incorrect. So probably the best thing to do as far as that's concerned is just list civil clerk or Attorney General of the United States or something like that. So those are a couple of things to remember regarding the IRS. I'm going to skip down to the bottom really quickly regarding the Georgia Department of Revenue. They are a lot simpler. Really, the only person that is designated to receive service on behalf of the Department of Revenue is the commissioner, him or herself, or someone designated by the commissioner if there's an interim commissioner or an acting commissioner or something like that. and the address is down there for your reference. So they're much simpler. Now, regarding service on the United States trustee, I've been hearing this misconception that the United States trustee is automatically included on every mailing matrix in every bankruptcy case that is filed. And that's actually not true. Although the United States trustee is applicable in every bankruptcy case that's filed, they are not automatically included on the mailing matrix. So if you do not add them, they will not receive service. So it's important to add them if you need to serve them. And the answer is probably going to be, yeah, you probably do need to serve the United States trustee. There's actually a rule about this, a federal rule of bankruptcy procedure. It's Rule 9034. It's in your materials, and it specifically lists all of the motions and pleadings that you are required to serve the United States trustee with. And I believe, I know Janine Treese is on the panel. She, as Melissa said, is the Assistant United States Trustee here in Region 21 for in the Atlanta office. And Janine, I think you wanted to add a couple of things regarding service on the United States Trustee.
Thank you. Yeah, I wanted to just point out that a lot of time, well, first of all, the U.S. trustee is rarely even a party listed on the docket in Chapter 13 cases. We're not automatically added. We are added to the docket on Chapter 7 cases. You'll see us as a party at the top. And you'll also see that notices go to NEFs, notices of electronic filing, go to some general mailbox. But that is not service on the U.S. trustee. The Office of the U.S. trustee is not a registered user. And so we do not get NEF service. That's a courtesy email we get, but we don't receive NEF service when you file something automatically in Chapter 7 cases. We get a notification that something's been filed, but we don't get that free look that constitutes NEF service. So it's a mistake to think that just because our main general email box is listed, that we're getting service that way. That is not service on the U.S. trustee.
Thank you, Janine. Appreciate that. All right, moving on from the government, a couple of quick things regarding service, and then I will turn it over to Janine. In joint cases, when you have a consumer case where there are two debtors and they're filing jointly, in order to perfect service on those two debtors, you have to serve them individually, separately, in two different envelopes with different postage on them. A lot of times I will see motions for relief from stay, particularly, and there, let's say the debtors are John and Jane Smith, and they, on the certificate of service, have served John and Jane Smith, 123 Main Street, Cartersville, Georgia. That's not proper. That's proper service on John Smith. It's not proper service on Jane Smith. So you would have to, even though they live in the same place, they live together at the same location, you have to put two different copies of your motion in two different envelopes, one to John Smith, one to Jane Smith, same address, different postage. I've seen a lot of motions denied for failure to serve joint debtors separately. And then, of course, the service requirements are different if the entity that you are serving is a depository institution insured by the FDIC. So this does not include credit unions. So that excludes a large group there. But the rules do require service on FDIC insured institutions via certified mail. And unless, of course, there's always exceptions to every rule. unless the institution has appeared via an attorney. If an attorney has filed a notice of appearance on behalf of the institution, you can serve that attorney via first class United States regular snail mail. Unless you have a court order that says something different, of course, or if the institution in writing has waived the requirement to be served via certified mail. Otherwise, you are required to serve them via certified mail. There's a question here. If you serve a party via certified mail when first class mail is required by the rules, is that service proper? There is case law that says no, it is not proper. There was an attorney who didn't want, just out of an abundance of caution, served everybody via certified mail, and that was it. He got a signature, saying everybody received notice, actually received the document, but the court ruled that that was not proper service because it did not follow the rules. They were not served via first class United States mail, and therefore they did not receive proper service. So it's important to know the rules and follow them, even if you're trying to go above and beyond and do a belt and suspenders. It's not always the best idea. Just follow the rule. And the last thing that I'll mention is the mailing matrix that you use. When you, on your certificate of service, when you refer to, those parties listed on the attached mailing matrix, make sure that you use a mailing matrix that was printed on the date that you're serving that motion. I know a lot of people have a lot of mailing matrices that were printed out, at the beginning of the case or at some point during the case, and then they'll just use that as to attach to the certificate of service and use that as what you work off of to serve. But a lot of things change throughout a case on a mailing matrix, and so you need to make sure that the mailing matrix that you use and that you work off of for service is one printed on the date that you're actually serving your motion. And then finally, I've given you a little reference list. It's not exclusive by any means, but it's just something quick for you to refer to. If the answer to your service question is not in this list, there is something in this list that will get you where you need to be. So I just wanted you to have a little reference guide in case you had an issue that you needed to look up. Hopefully this will be helpful. Thank you all so much. Janine, over to you.
Okay, thanks, Brandy. Because I'm a government employee, before I start talking, I have to make a disclaimer, and that is that the comments that I make today are my own and not those of the United States Trustee Program or the U.S. Trustee. So I'm charged with the responsibility for discussing hearings, and I'm going to say something that you've already heard from everyone else who is speaking today, and that is consult the clerk's website and consult the judge's webpage. They really do have a lot of information. The judges have taken a lot of time to provide this information. And another source are the courtroom deputy emails that you receive with instructions about hearings. So with that said, I'm going to start with kind of in a linear fashion. The first point being that we do use an open calendaring procedure and have for many, many years, which means the attorney is responsible for choosing the hearing date for motions and applications, except as otherwise instructed. Unless something's specially set, you go to the court's webpage and look for the open calendar procedures and the available hearing dates and select the hearing date that you want to use for your hearing. It's important to make sure the hearing date is far enough out so that you're providing adequate notice. And it's important to avoid scheduling conflicts for yourself. So make sure you're not scheduling a hearing on a date when you're to be in front of another judge or at a 341 meeting or have a personal matter. But again, consult the judge's webpage for the particulars. It's really not fun to get to a hearing and find out that the hearing's not going forward because it's a matter that has to be specially set, and it certainly doesn't make you popular with your client or any other person that you've arranged to have her available that date. So be sure to check the judge's webpage for instructions about what types of matters must be specially set. Each judge has particulars for this. Examples would be something that's going to take 15 minutes or more. At some judges, it's 20 minutes or more. A hearing that needs to be in person, such as an evidentiary hearing. So again, just consult the webpage to see if it's something that needs to be specially set. The voluntary notice procedure is something that I enjoy using because it frees up some of your time. You're not having to sit through calendar calls and go to hearings if there's no objection. So General Order 24, 2018, which has been amended most recently, December 8th, 2021, provides a laundry list of matters that can be considered by the court without an actual hearing if no party objects by a deadline and if an order has been entered approving the motion at least one business day prior to the scheduled hearing dates. There are many caveats. It's really, really important to carefully read the general order and the exhibit to the general order. So first of all, there's a laundry list of things that are subject to the voluntary notice procedure. Not everything can be set using this procedure. So make sure the thing you want to set is one of the things on the laundry list. Second most important caveat to me is the form of the notice. There's a very specific form of notice that is not editable. You can't get creative with it. You've got to use that form. So make sure you're using that form of notice or the procedure doesn't apply. Absent a federal rule or a local rule, generally a response period should be a minimum of 21 days. So you give people 21 days from the date of service to file their objection, and make sure you've got the date of service on there. I've seen people say, you have 21 days from the date of service, and then nowhere on the notice is the date of service listed. That just boggles my mind. Be aware that the Chapter 13 trustee is not required to respond. So if you want the procedure to apply, you have to obtain, as you do on any order, their consent, 13 trustees' consent. The court always retains discretion to hear a matter. So don't assume and count your chickens or before they hatch that you're not going to have to go to a hearing. So put it on your calendar, plan to be there, submit your order in a timely fashion, monitor the docket for entry of the order, but be aware that it may be something the judge wants to hear. So you should be prepared to attend the hearing. Do not call chambers to check up on the order. That I'm sure will drive the judge's staff crazy. It's your responsibility for monitoring the docket and making sure the order's entered, or if it's not, that you're prepared to go. There are also rules or requirements for verbiage that must be in the order. So I'm going to mention a few of them. The order must expressly state that notice and opportunity to object was given pursuant to the general order, that no objection was timely filed, that the court considered the motion in all matters, including the absence of an objection, that no further notice is required, and that good cause exists for granting the motion. So again, really read the order, the general order, read the form of the notice. But once you do, it's a really wonderful procedure and it saves everybody a lot of time. So moving on, the next thing you need to do is to prepare yourself. So again, review the court's website, review the judge's webpage for instructions for the hearing and what's required and expected of attorneys. The next step is to also prepare your client. So communicate with them. What is scheduled? What is it that's going to be heard? When is it scheduled? What's going to happen at the hearing? Just what they should expect the whole process to look like. Who's going to be there? How they are going to participate as far as just technical requirements. Make sure they have the ability to comply with the technical requirements. Make sure they're aware of proper court attire. Make sure that their client's aware of proper court conduct, including things such as muting the phone, not recording the proceedings, appearing from a quiet place and an appropriate place, not driving down the highway, right? Make sure that they're free of distractions, not taking care of children or doing other things, or being at work or having their lunch or whatever. and waiting until they're called upon to speak. And at this point, with her permission, I'm going to turn this over briefly to Shannon for some other tips on conveying important information to your client about court appearances.
Hey, yes, absolutely. Hi, everyone. So just to give a little information as it pertains to how our office prepares for any sort of hearing, whether it's the 341 hearing, a confirmation hearing, or any sort of miscellaneous hearing, we typically, I'll just start at the beginning. We typically send out an email to the client notifying them of the date and time of the hearing. As the hearing draws closer, we will then send out a text message to the client to let them know the date and time of the hearing, and to also inform them that they will have a prep session with myself or my business partner, Nicole. During the course of that prep session, it's usually about 24 hours prior to the hearing. During the course of that prep session, we will go over basically everything that Janine just stated, everything from who will be at the hearing, will there be other debtors at the hearing, properly putting your call on mute if you are not being spoken to at that time, what the call of the calendar is, what your actual hearing will look like. And this may take a little bit of time, but it's well worth it and it's extremely efficient to do. Not just for the attorneys, but for the client. So they aren't caught off guard, they're fully aware, and they understand the process that is happening while they're actually on the court call. It's substantially different from when we used to be in the 341 rooms. So because we do not have that illustration and we can tell the client, you know, you can sit here and you can kind of listen out for what the questions will be and what you can anticipate. It's now our jobs as the attorneys, it's incumbent upon us to let them know, hey, you may have objections, but this is normal. Everyone will receive objections. This is what the questions will sound like. This is what you can anticipate. And even giving them an idea of what projected objections they may have. So Nicole and I will actually let our clients know, hey, prior to filing, you did not provide us with your, we'll use a tax return. And it may have been because taxes did not come due at the time. They weren't required to file it by that time, but by the time of their hearing, it's now due. So we can anticipate this as an objection. Don't fret, don't be upset. Just know that we'll have to get that done. So anticipating certain things as well is a good way to prepare the clients. I think just being in constant communication with the clients, whether it's by way of email, by way of text message, and also that telephone call. We really don't have clients coming into our offices anymore. If they're coming into the office, it's an absolute need, but otherwise you can communicate this information effectively and provide your client with the information needed so that the hearing can go smoothly.
Thanks, Shannon. The next thing to do to prepare before the hearing is confer with opposing counsel and see if you can resolve things, see if you can narrow the issues, just make sure you're kind of on the same page so you're not having to kind of react by a surprise. Continuances, generally, don't assume you're going to get a continuance. You can't under the bankruptcy local rules, they can't be stipulated, but they have to be approved by the court. So make sure you've taken care of that well in advance. Absence of witnesses. And again, there are local rules for all this. And every once in a while, it's kind of a good thing to go back and read the local rules, because sometimes if you don't use them, you forget about them. So I liked this presentation as an opportunity for me and other people to go back and look at the local rules. But there's a local rule regarding absence of witnesses. And if you want a continuance due to an absence of witness, your motion has to identify steps taken to secure attendance, the nature of the witness's testimony, and when the witness will be available. Has to include a physician certificate if there's an illness that's alleged. And a stipulation of witness's testimony constitutes cause to deny the motion. So be aware of that as well. If you have a conflict with a 341 meeting, in other words, you have a hearing scheduled at the same time as the 341, you need to give prompt notice of the conflict and a proposed resolution to the trustee, the 7 trustee, the 13 trustee, and the US trustee. There are also local rules regarding the exhibits. and it's local rule 9017-1. And if you expect to offer exhibits into evidence, there's a procedure for that. You have to sequentially number the exhibits prior to the hearing and mark them, and provide an exhibit list to opposing counsel, and that includes any unrepresented party, and to the court, and provide a copy of any exhibit for inspection and use by opposing counsel at the time it's introduced at trial. So just make sure you've reviewed the rule about presentation of exhibits. Be aware, though, sometimes the court may issue an order specific to your case or your matter regarding the presentation of exhibits, and obviously that's going to control. On to virtual court hearings. Again, refer to the judge's chambers page for specific calendaring hearing information. There are a lot of similarities between and among the judges, but there are some differences. So it's really important to know the particulars of the judge before whom you're appearing. Generally, the recommendation is to join the meeting, the virtual hearing, 10 to 15 minutes before the hearing time. And that's one of the things that differs from judge to judge. If you're having trouble with connections, generally the instruction on the judge's webpage is to contact the courtroom deputy clerk by email to let them know that there's a problem. You're supposed to make sure your first and last name are displayed on the screen. That's not always the default. I know when I first appeared the first time, it didn't have my whole name. So make sure that you've done that. As we've said several times, place the call on mute unless you're addressing the court. We all know you're prohibited from recording or broadcasting the proceedings. Be mindful of your background. Is there anything distracting or inappropriate in your background? Think about that. Maybe blur your background. Again, attend from a quiet place free of background noises. Put your phone on mute. But then you got to remember to unmute it. That happened to me the other day. I put it on mute, and then I didn't take a call for the rest of the day because my phone was on mute the rest of the day, which can be convenient. Obviously, dress and act as if you're in a courtroom. Wear court attire. Again, really, you should be in an appropriate location, not driving around down the highway, and not doing things that you wouldn't do if you're in court. You shouldn't be eating and drinking and smoking while you're on camera. Most of the courts prefer that you use headphones or earphones, again, to block background noises. And they request that you identify yourself every time you speak. The requirements for telephonic appearance are generally the same as being on camera, meaning, muting yourself, identifying yourself, etc. And I wanted to turn it over at this time to Brandy to kind of talk about mass calendars. One of the questions I posed for her when we were preparing for this presentation was, gone are the days of lining up at the table at the Chapter 13 trustees attorney table to kind of go over things and negotiate things right at the last minute before the hearing. So I asked kind of how's that being done now, and does she have any tips? So Brandy?
Yes, it's a whole different world out there now. I remember, back in the day where people would line up to see the trustee or sign up on a sheet to talk with the trustee or their staff attorney regarding the matters on that day's calendar. And it really differs by judge nowadays. For example, like in, as you know, I represent Ed Zafir in Judge Bonifel's courtroom, and typically there is the goal is to get everything that can be resolved prior to the day of the hearing. And then the matters that need to be heard by the court, obviously, will announce ready at the call of the calendar, and that matter will be heard by the court. But the goal is not to discuss any matters or try to work out things during the court call itself, unless it's absolutely necessary, as it's, it's just not the same. You don't have the same opportunities that you used to when you were face-to-face and physically in the courtroom. Everybody's kind of stuck on the same line, and everyone can hear. So it's difficult to for a trustee or their staff attorney to speak with a debtor's attorney or creditor's attorney regarding matters specific to a case. A lot of times it contains personally identifiable information that should not be heard by everybody else on the line, but it is. So if it's possible to work things out beforehand, that's preferable. I know, I think that there are other courtrooms where some conversation is being held on the actual call prior to the call of the calendar. But I know there are also some courtroom deputies that, won't, the requirement, as Janine said earlier, is that you connect to the call either 10 to 15 minutes prior to the actual call of the calendar. And that doesn't leave much time to discuss really anything. If you do have an emergency or a last minute something that you need to speak with the trustee or their staff attorney about prior on the morning of a hearing prior to the call of the calendar, instead of actually speaking to them on the line, it's probably best to send them an email or give them a call direct at the office, because like I said, you don't want that conversation going on where 100 other people can hear you. So that's just a quick kind of recap of how things are going nowadays, now that we're solely virtual, at least for the calendar calls.
Thanks. On to you, Shannon.
All right, so now we're in the home stretch as it pertains to properly prosecuting your motion. And we are at your proposed order, which is extremely important. I know that this particular session was really geared towards the newer attorneys and some of the attorneys that may not have had the experience over the past 2 years. So that's who I will be talking to specifically. And it may seem a little bit elementary as it pertains to what I drew out here, but I can remember being a very young attorney and sending in my proposed order to Judge Murphy and it being returned with all that red ink. So if you guys remember that, that is not what you want. So we are going to start at the most basic levels because you want to get it right and you want to be professional. And even when you are proposing an order, you are still advocating for your clients, even at this stage. So you want to make sure that you leave about 4 inches for that margin, right? You want to get that right. If you don't get that right, it will get kicked back. So you want to make sure you do that. Be sure that the style of the case is correct. I know some of my colleagues on the panel have already indicated that a lot of us kind of have our templates and we kind of have our process by which we send in our proposed orders. But sometimes you can kind of get lost in just the very, I guess, the mundane ways of doing things, and it's automated. So you're not paying attention to those very particular things, such as the chapter or the division, and you don't change those. And that is important because every case is unique. So that may seem something that may be so trivial and like, oh, of course I will get that right, but you'll be surprised. A lot of motions get kicked back because of that very reason. You want to be sure to include in your title if this is a consent order, or if it is a consent order, you want to make sure that that is indeed in the title. The text of your order, which is, I would say, the meat and the potatoes of it. So here we don't necessarily have anything for the text of the order. I actually got this from the court's website. And this particular example would be deemed like a caption format of an order, right? So it doesn't have like the actual substantive part of the order or the meat and potatoes part of the order. But just to kind of give you a breakdown of what that would consist of, typically in the text of the order, you want to indicate who filed the actual motion. You want to indicate the actual docket number associated with the motion that was filed. So if you filed an application to employ special counsel and it was docket entry numbered 62, you want to make sure that you refer back to that in the actual text of the order. You also want to indicate who was there at the actual hearing, if there was a hearing. You want to indicate what was sought in the motion. And this is typically, I would say the first paragraph is probably no more than maybe 3 to 5 sentences. It isn't long at all. What type of hearing was held? Was it, I know we do this specifically, was it telephonic? Was it a virtual hearing? Was it in person? And you want to indicate what actually happened. Was it heard or was it consented to by you and opposing counsel, by you and one of the staff attorneys or one of the trustees? And then you, in that second paragraph, that's typically when you get into what was actually ordered. And you would continue to do that, what was ordered, until the end of your actual text. And at the end of your actual text, underneath that, you want to place end of document. And this must be placed at the end of the text of the proposed order. And we can go to the next slide. The very next page, you do want to list all of the parties that have consented to the order, or even the parties that didn't have any opposition to the particular order that you are proposing. This may seem a bit ancillary, but it is important. So I know something that we spoke about. There are a lot of orders that are being proposed or uploaded rather, and it's just indicating, we'll say for instance, for the Chapter 13 trustees, Melissa consented to this order, and that may not have been the case, you know. It may have been one of her staff attorneys in the office. So you want to be very specific about who consented to the actual order. You don't want to just say that it was Melissa, Nancy, or Ed. You want to be specific as it pertains to who you were working with in their office, and you want to put down the information needed in the signature blocks. Aaron spoke about the signature blocks as it pertains to it being listed on the motions, but it being listed on the actual order. It's very important because you do want to indicate the role that every party may have played that is listed in this particular section. And according to the local rules, the signature block is more than necessary. It is needed. One of the main things, you do want to list the email address for any attorneys that may have consented to the order or had no opposition to the orders. That is extremely important. And you want to continue to do this as many times as you need to. Again, as I indicated, this particular caption format order here was listed on the court's website, and I did provide the link. And down at the bottom, you will see the distribution list. This is extremely important because this is who the clerk's office will serve. So you want to make sure you have who will need to be served on there as well. And we can go to the next slide. So preparation of the proposed order. You want to be mindful that all of your orders are due within 7 days from the date of the scheduled hearing or when it was announced. However, I believe it's 24 hours for orders as it pertains to negative notice. Please, someone correct me if I'm wrong. I believe it's 24 hours. Typically, when I do negative notice motions, I kind of simultaneously will just upload my order at the same time when I'm submitting the motion. So that may be a good way to do it, but otherwise it would need to be submitted about 24 hours prior to the actual hearing date that is on the negative notice motion. Again, the order should list the hearing. Again, the order should list the hearing date in which the matter was heard or the scheduled hearing. The proposed order should accurately reflect the bankruptcy judge's verbal ruling or the proceeding at the calling of the matter as applicable. Now is not the time to add any additional relief. If you did not seek this relief in your motion, now is not the time to just make up something. One, that's inappropriate. Now is not the time to make up something and put it in there, and now you have like this made up fairy tale land relief in there. So you do not want to do that. And every order should be signed, as I indicated, by each party or consenting party. And you guys can refer to the prior slide for that. And as it pertains to submitting your order, prior to submitting it, you may want to get the consent of opposing counsel, whether that be an attorney for a mortgage creditor, a car creditor, a debtor's attorney, or the staff attorneys. Most of the staff attorneys or at the trustee's office for the Chapter 13 trustees, they have an email address. We will typically, when I say we, Nicole and I, we will typically just email the staff attorney that we were corresponding with and say, hey, here's an order. Can you consent to this? And they'll let us know. But there are email addresses and or a link on their webpage where you can submit your order accordingly. And they will get it back to you in a timely fashion. So you want to take advantage of utilizing those links and those email addresses so that you can get your orders uploaded within that 7-day period of time. And I think that could possibly be it for me. Aaron, you want to go to the next? Oh, okay. I spoke too soon. Okay, and the uploading, the uploading process. This can be a bit tricky, but you want to make sure that your order is in PDF format, that you have your case number readily available, because as you are uploading your order, the different prompts as you are uploading, one of the very first things it will ask you if you have your case number, and you'll have to input that because you want to make sure it's associated with the right case, right? Your order must relate to a specific document in the case proceedings. So you will have to select the event or the docket entry in which you are uploading an order for. And then you will kind of follow the prompts and you will select each of the following items accordingly. Is it a single order? Entering your case number, identifying the docket or the related docket number. Select the type of document, whether it's an appeal, a motion, an answer, and then you want to, again, make sure that you are relating it to the appropriate motion. Sometimes we can have motions that are related, and you want to make sure it is related to the appropriate motion. You then wait for your confirmation, and then once that takes place, if there are any deficiencies, you want to be sure that you are checking the email address that you put on file with ECF. If you do not check that email address on the regular, there will be tons of deficiencies just kind of sitting in your inbox. So you want to make sure you clear that out and rectify any deficiencies that you may have or that the court may have, and get that done quickly. And be kind when you're getting that done. You are still at the mercy of the court, and this is for your client, and you are in the home stretch at this point. So the fact that the court even lets us know, hey, these are the deficiencies, correct them accordingly, that's a great privilege in itself. And there is also a step-by-step picture guide relating to the uploading of orders as well. And that's it for me, guys.
All right, thanks, Shannon. I just wanted to add a few comments. I think Shannon touched on this, but make sure your staff understand what they're doing when they're uploading orders. Oftentimes it will come back to me from chambers that I signed an order and I didn't sign the order. Either it was never sent to my office or it was my staff attorney. When you are signing an order for another attorney, you have to have express permission from that individual. It's filed under their bar number. So make sure it is the correct person. Also, make sure your staff understand that just because someone announced in court that they do not oppose a motion, that does not mean that they have signed off on that order. We also hear that sometimes, that staff misunderstands, and so they'll submit an order just because there was an announcement in court. So make sure, that seems very basic, but your staff might not understand that. So make sure you explain that to them. I would also say that there is a very useful procedures manual on the court's website for ECF matters that you can utilize, you can search. There's also a help desk. So if you have any questions about filing motions, the proper way to file it or to upload orders, that's helpful. One other note that I wrote down during our presentation that I wanted to highlight was just that just be mindful, this is especially for younger attorneys, the United States Trustee Program is part of the executive branch, and they are not part of the judiciary, obviously, but they are in charge of 341 meetings of creditors and those matters, which are not court hearings. So whenever you're dealing with 341 meetings, just keep that in mind. Keep in mind that the United States Trustee has jurisdiction over those and not necessarily the bankruptcy court in terms of notice and scheduling, even though the court certainly schedules them. All right, so I'm going to check. I have not seen any questions in our chat box, but if anybody has any questions, please let us know. I did want to thank everyone for attending and also highlight the website. The court has a link to the Bench and Bar Committee tab, and all of the past presentations that we've done, as well as this presentation, is on that link. If you have any ideas for panels, for future panels, or you have any matters at the Bench and Bar Committee that you would like for the committee to consider, please email. There's an email address for the Bench and Bar Committee on the court's website. And otherwise, I would thank everyone for attending, and we hope to see you again in a few months.